I'm firearms attorney Gilbert Ambler, and I'm back today at a very exciting time to talk to you about what President Trump should be doing with respect to the Second Amendment. And of course, there's a lot going on because we've recently learned that Kash Patel is going to lead not only the FBI, but also the ATF. And I'm sure there's going to be hundreds of videos circulating on YouTube about what Kash can do in leading the ATF and all the things he can improve. And I'm here for all of it. I'm excited for all of it, but that's not the subject of this video. The subject of this video is to tell you why President Trump should immediately call upon Congress to pass an assault weapons ban. And you probably never thought you'd hear me say that, and I can already see the comments section filling up with all sorts of nasty comments, calling me a bootlicker and everything else, but I'm suggesting it for a pro-gun reason. And I'm about to explain to you what that reason is and how this could really be a 4D chess move. Before we dive into this subject, however, if you have not yet hit that subscribe button, what are you waiting for? Hit subscribe, like, comment with your thoughts, share with your friends. That way you and your friends can keep getting this important Second Amendment related content. Now, why am I suggesting that President Trump, because you know me, I'm a pro-gun guy, why am I saying that Trump should ask Congress to pass an assault weapons ban? And I'll tell you what got me leading on this path. What got me going down this path was thinking about the things that the Attorney General might be reporting back at the end of the 30-day window. And to take a couple of steps back here, President Trump issued an executive order, and the return date on this executive order is going to be March 9th, 2025. Telling the Attorney General to evaluate in what ways they could make sure that the Second Amendment is being respected, and that means going through Biden-era policies, seeing if there's any policies that need to be corrected, taking a look at the DOJ's stance in ongoing litigation. And it occurred to me that there's a couple things right off the bat that the AG can and should do in to comply with this executive order. For example, in any of litigation where the federal government is a party. So these would be challenges to things like 18 to 20-year-olds purchasing handguns from an FFL. The federal government has been sued on that. The DOJ is defending the law. It's bans on firearms in sensitive places like post offices. Again, federal government has been sued. DOJ is currently defending. It is bans on persons that are prohibited by way of using marijuana from possessing firearms. Again, ATF has been sued, DOJ is defending. In any of those cases where there is active litigation going, the Attorney General can and should come back to President Trump and say, we will stop defending these. We will sign consent decrees agreeing that the laws at issue are unconstitutional. And the significance of that is the consent decree can spell out exactly why the law is unconstitutional. And once a judge signs off on those consent decrees, then the law of the case doctrine and res judicata, which are two legal concepts, kick in. And these legal constructs or these legal concepts are designed to prevent things from having to be litigated over and over and over again. The idea is once a court decides a particular issue, we should be able to rely on that decision moving forwards. We shouldn't have to relitigate it again in the future. So if, for example, there were a binding decision from a judge, maybe even a binding decision as part of a consent decree, that a ban on firearms in post offices that are otherwise unguarded is unconstitutional, arguably, even if a future administration tried to reimpose such a ban, the law of the case doctrine and res judicata would kick in and we wouldn't have to relitigate that issue. We'd say, look, the courts have already considered this. The parties have already considered it. The government has already agreed it's unconstitutional. We can't revisit this issue. And that got me thinking about assault weapons. And I'm using that term assault weapons because we know that's what the anti-gun side is going to use. And we know that that is on the dream wish list of any future anti-gun president. They're going to want to ban assault weapons. And we could take all the ability of them to do that off the table. It would be the ball game if we did this successfully. What would this look like? It would look like Congress passing a law banning assault weapons right now. And they don't have to ban assault weapons effective today. They could pass a law effective in banning assault weapons in 2035 that would still allow us to challenge the law today. So the gun ban gets passed. We challenge it. Trump's attorney general, at Trump's direction, could either not defend it, could enter a consent decree, or could quite literally do a terrible job defending it, not show up with any historical justifications, essentially plead public policy, which Brune forecloses, and throw the game, throw the case, lose on purpose, or enter a consent decree agreeing and stipulating that an assault weapons ban is unconstitutional. And once that is signed off on by a court of competent jurisdiction, then the law of the case doctrine prevents us from having to relitigate that issue again in the future. And there were people out there that said this is what Trump did when he directed the ATF to ban bump stocks, was that he was setting it up because he knew that otherwise Congress would ban bump stocks and that would be more difficult to undo. So he was playing 4D chess, and he had the agency do it with administrative action, and then he knew that would be right to challenge. I was very skeptical. I didn't necessarily believe that he was looking that many steps down the road and playing 4D chess in that way. But if he's playing 4D chess, this would be a 4D chess move. And of course, the other thing that the AG can do right now is when they come back and report back to President Trump about how they can respect the Second Amendment, in addition to all the current cases that they have going on, settling them, they can also start filing amicus briefs in all the cases at the state level, because there's lots of lawsuits going on challenging state laws. You know, the United States government has not banned the carry of firearms in parks and at permanent events and all of these other areas that states have attempted to ban firearms at. So, although the Attorney General would not directly be involved in those cases, they can and they should get involved by filing amicus briefs at the state level in any challenges to state laws. So, and it's a little bit complicated here because a lot of these challenges are in federal court. For example, Virginia has allowed localities to ban firearms in parks. There is a current federal challenge to the gun ban in Fairfax parks going on. That is a Second Amendment challenge taking place in federal court, but against the state government. So the federal government is not defending that case, but they can and they should get involved by filing an amicus brief on behalf of the plaintiffs, on behalf of the people trying to knock the gun ban down, saying, we agree this is an unconstitutional restriction. So, as I said, I hope you actually watched this whole video, because if you didn't make it to this point where we're talking right now, you probably think I'm a terrible person who wants to have immoral and unconstitutional assault weapons bans in place. Clearly, I don't actually want that, but I want to set them up, and I want to, make this the entire ball game right now. And so maybe it's a little bit far-fetched, but it's an idea that would have very long-lasting ramifications if everything went successfully. If you enjoyed this content, hit like, hit subscribe. Until next time.